All right, so based on my watch, we're about 1 or 2 minutes past 6. So we are going to go ahead and get started with the presentation for this evening, which is the 2023 case law update. As I mentioned earlier, if you could please make sure that you are muted. Feel free if you'd like to leave your video on. You certainly can do so, but making sure that you're muted will help make sure that we are able to, is able to hear the presentation and just reduce all that feedback that comes from multiple microphones being open. So with that said, my name is Kayleigh Long. I am a member here at Hirzel Law, and I am going to be taking you through today's case law update, which is going to kind of summarize and wrap up the important cases that community associations should know about that were decided in 2023. So today's cases, we are primarily going to be discussing 11 different cases across 7 different categories. And you can see those here. So the cases from this year that are really important to community associations deal with fines, assessments, premises liability, or in layman's terms, basically slip and fall cases, short-term rentals, sex offender restrictions, always a fun topic, emotional support animals, and then last but not least, interest and usury, which I think out of the many years that I've done this presentation, this is the first time that particular topic has come up. So it was a very interesting year. So with each case, I'm going to provide you with just a brief background of the facts. I'm going to talk with you about what the court said, and then what community associations should take away from each case, and basically the important lessons that we learned from those cases. So first up is actually a case that our law firm handled. It deals with fines, and it is Channelview East Condo Association versus Ferguson. And the issue on appeal here was whether the association's fines of $135,000 were reasonable. So this case actually, this was the third time this case was up on appeal. It made its way back and forth between the trial court and the Court of Appeals multiple times. In the prior appeal, the Court of Appeals had determined that the co-owner had committed a bylaw violation and that the association could fine that co-owner for those violations. However, the issue that went up on appeal again for the third time was whether the association's fines of $135,000 were reasonable. So in this particular case, we had here a bylaw violation that stemmed from a house that needed to be constructed no later than 12 months from when the construction started. So that's a pretty common provision in site condominiums of once you start construction of your house, you want it to be completed within 12 months. In this case, that did not happen. In fact, that house was not built for several years, over 10 years. And so during that time, the defendant was notified of his violation back in 2005, and the association imposed an escalating fine schedule that began in November 2005 related to that bylaw violation. So the association said, we're going to fine you $100 per month for the first 3 months. Then we're going to fine you $500 a month for the following 3 months. And then there's going to be a fine of $1,000 a month for every month after that this violation continues and the construction remains incomplete. And of course, it got up to $135,000 because the house just never got complete over several years worth of time. So the trial court decided that $135,000 in fines was reasonable in this case, and the Court of Appeals affirmed that decision. And basically the Court of Appeals said, listen, this is not going to necessarily apply in every single circumstance across the board, and the reasonableness of a fine is really going to be determined on a case-by-case basis and is going to turn on the facts circumstances, and nature of the violation. So in this particular case, both the trial court and the Court of Appeals focused on the fact that the violation continued for years on end. And they also focus on the fact, and they seem to give some discretion or deference to the association for using an escalating fine schedule. So they didn't come out of the gate with $1,000 fine per month. They started with a lower $100 per month for 3 months, $500 per month for 3 months, and then $1,000 per month after that. And that was designed, and there was testimony from the association in the trial court that said, we did it that way because we wanted to encourage the co-owner to comply. We didn't want to have to get to litigation. We didn't want to have to get to the $1,000 per month. We just wanted the house to be built. And so we wanted to impose smaller fines on the front end to encourage the co-owner to comply with the violation. But unfortunately, that didn't happen in this case. And the Court of Appeals also noted that the defendant, in challenging the reasonableness of the fine, failed to offer any evidence regarding what they believed to constitute a reasonable fine. So their only defense was this fine is just unreasonable, and they left it at that. So first of all, this is an unpublished case, which means it's only persuasive authority. It's not binding on the Michigan trial courts. But the takeaway here is that it really was a positive outcome for community associations. But as I noted, there's the caveat. This case does not mean that $1,000 per month fine accumulating all the way up to $135,000 is always going to be considered reasonable in every single circumstance for every single violation. Instead, as the Court of Appeals stressed, whether a fine is going to be reasonable or not is going to need to be considered on a case-by-case basis, and you have to take in consideration the nature of the violation and the facts and the circumstances that are surrounding that violation. So, with that said, the next topic that we're going to be discussing is assessments. So this is one of our few cases dealing with a subdivision association, not a condo association. So this is the case Walsh versus Hawthorne Hills, owners of Rochester Incorporated. So the issue on appeal here was whether the association had authority to implement a street lighting project in the community. So the subdivision association went out and got approval from 59% of their members to increase their annual dues in order to fund, in part, a street lighting project. That would not only add accent lighting to the community, but also increase safety and security in the community. Interestingly here, the plaintiff homeowner in the case voted in favor of that annual dues increase, said, yep, I approve. This street lighting project sounds great to me. But then later filed litigation saying, actually, I think that this actually needed to be levied as a special assessment, which means it would have needed approval by 2/3 of the members, not just 59%, because it wasn't appropriately categorized as an annual due. And this is based off of language within the subdivision's restrictions, which said annual dues could only be used for expenses of a general and reoccurring nature. So the Michigan Court of Appeals, the trial court said this is a general and reoccurring in nature expense. So this is properly considered as an annual due. And so therefore it was properly approved by the members, and the Court of Appeals agreed. A lot of this case turned on the language within the subdivision's restrictions. And so as you can see, I provided some of those pertinent provisions here. So in this case, the restrictions said that the maintenance fund could be used to improve and maintain the common areas and do any other thing that's necessary or advisable for the general welfare of the members. And for increase in annual dues, the declaration only required approval from 51% of the members. The association got more than that. They got 59%. And then their accompanying bylaws said that the association could use the annual budget and those annual dues for any expenses of a general and reoccurring nature. And so the Court of Appeals said, well, an expense of a general nature we think the street lighting improvement project qualifies for that because streetlights are just a common staple within a community and they affect the entire community. It's not benefiting just one part of the community. Everyone's going to benefit from that. And it's just a thing a lot of communities have. And they also said that the street lighting project qualified as a reoccurring in nature expense because basically your street lights are going to be used basically every single night and you're going to have a reoccurring expense from those utilities, maintaining the street lights, repairing them, etc. So the Court of Appeals said, all right, this checks all the boxes based on the language within your declaration, your bylaws. This qualifies as a general reoccurring expense. Therefore, it's an annual due. You got more than 51% approval from your members. So it didn't need to get approval of 2/3 of the members as a special assessment. And additionally, too, the Court of Appeals noted that the cost to fund the street lighting improvement project were included as the annual dues. So the members didn't receive an additional or separate invoice just to fund the street lighting project. It was all encompassed into the annual budget, all assessed to the members as part of their annual dues. So the takeaway in this case is, again, the focus here is that the result in this case turned largely on the language within the association's governing documents. So whether you're a condominium association or subdivision association, if you are considering undertaking a new project within your community, you should carefully review the language within your governing documents to determine whether funding that project is going to require prior approval of the members or not. And if it is, what level of approval do you need? And it seems here that the association did a good job of ascertaining that up front. So the next group of cases, we're actually going to be discussing two and kind of a bonus case in there as well. So premises liability. So these are your slip and fall personal injury cases. I think that we all love and enjoy. So the first case, unpublished opinion. So again, only persuasive authority, not binding on the trial courts. But the issue here on appeal was whether the condominium association and their property management company were liable to a co-owner who suffered injuries from a fall on an icy sidewalk. So it's important to remember here, we're dealing both with a condominium and a co-owner. So the ice, it was at least alleged in the trial court that the ice on that common element sidewalk that she slipped and fell on came from a leaking gutter that the co-owner had reported to the association and management company several times and apparently had not fixed and corrected. So water is leaking out from this leaking gutter and it ends up resulting in ice on the sidewalk. Co-owner is trying to get to her carport. She slips and falls and suffers some injuries. So of course, the co-owner decides that she's going to file premise liability and negligence claims against both the association and the management company for her injuries. So the trial court decided that the association and property management company were not liable for her injuries, and the Court of Appeals agreed. So to understand the difference between premise liabilities and negligence claims, it's a little bit of law school knowledge for you. So premise liability claims are essentially a form of a negligence claim, but they deal specifically with dangerous conditions of the land. So if a co-owner or another individual is bringing some sort of claim related to personal injury that's based off of, ice on a sidewalk, other things like that, something to do with the condition of the land itself or a dangerous condition of the land, that's going to be considered a premises liability claim, not necessarily a negligence claim. And when you bring a premises liability claim, the plaintiff has to show that the defendant, whoever you sued, owed you a duty, and that those defendants either owned, possessed, or occupied the land. And you also need to show the extent of that duty is going to depend on the status of yourself, the plaintiff. So are you, and this gets into lots of legal terminology, an invitee, somebody who's specifically invited to the property, like a contractor? Are you a licensee, someone who's just permitted to be on the property, or are you a trespasser? So there's various levels of duties that somebody who owns, possesses, or occupies the land may owe to somebody who enters the land. In this case, though, the Court of Appeals said, co-owner, your condominium association does not owe you any duty because since you are a co-owner, you have a joint interest in the common elements. So therefore, you also are an owner of the land. And therefore, the association owes you no duty. So therefore, you have no premises liability claim against the association. And as a result, the management company. And that was based off of a previous case decided by the Court of Appeals in 2015. So that largely has barred many premise liability claims by co-owners against their condominium associations regarding premise liability claims relating to the common elements. Because the co-owner also is an owner of those common elements, they're not necessarily going to be successful in bringing a premises liability claim. And as I said, premises liability claims are going to, in many cases, bar similar negligence claims. And that's why her negligence claim was also dismissed as well. Because her claim was based on the dangerous condition of the land, the Court of Appeals said, you don't get both. That's a premises liability claim. We've dismissed it. So your negligence claim is going to be dismissed as well. And notably here, the Court of Appeals indicated as well that that also extended to her claim that the association and management company were negligent in failing to correct the leaking gutter that resulted in the ice. So basically, her attempt to get around the premises liability claim and add on the negligence claim by saying it's not just the dangerous condition of the land, it was your failure to fix and correct the leaking gutter that led to the dangerous condition on the land, which led to my injuries. Court of Appeals said, no, that's not going to work. Now, there is a huge caveat to this decision. You can see I have yellow exclamation mark on this slide. So this decision, as I said, was based on a binding case from the Court of Appeals in 2015, which again said condominium associations, condominium co-owners, you're not going to be able to bring a premises liability claim relating to common elements that you, a co-owner, have an interest in jointly own in. However, in November of this past year, the Michigan Supreme Court heard oral argument in a case that is seeking to overturn that decision. We have not yet received a decision from the Michigan Supreme Court on whether they're going to grant that application, they're going to overturn the case. But that is something to keep in the back of your minds moving forward. This is a shifting landscape, and it could shift considerably in 2024 if the Michigan Supreme Court decides to overturn that prior case, which set up that precedent. Also, another thing that happened this past year, unrelated to condominium associations, but still may impact condominium associations moving forward, and which also will impact subdivision associations, is that the Michigan Supreme Court overruled its prior precedents regarding what's known as the open and obvious doctrine. So that's commonly comes up in cases where somebody trips and falls on a raised sidewalk, something where the condition was open and obvious. You saw it, and that somehow you still slipped, fell, injured yourself. Many times before this July 28th, 2023 decision, a defendant they were sued for a premises liability claim, and they had a defense of open and obvious, or that the condition was open and obvious. They could file a motion to dismiss pretty early on, and many times, if the court found that the condition was open and obvious, the case could be dismissed without having to go to a trial. The Michigan Supreme Court said, no. The trial courts have been dismissing these cases too early, basically saying you were considering the open and obvious doctrine under the first element of a premises liability claim, but it actually needs to be considered under the second element of a claim and the fault between the parties and it basically comes down to whether there was a breach of the duty and the comparative fault between the plaintiff, the person who fell, and the defendant, the owner, occupier, possessor of the land, and the condition of the land itself. So in layman's terms, all of this means that it's going to be much more difficult for a defendant to quickly dismiss a case under the open and obvious doctrine. And a lot of more of these slip and fall cases are going to be going to jury trials in order to make findings of fact regarding whether a duty was breached and the relative fault between the two parties involved. So this case, as of now, Jones versus Universal City States Association is a good result for condo associations and property management companies. But I will note that it's not necessarily get out of jail free card. Not to say you don't have to maintain your common elements that the association is responsible for. As I said, it is possible that the precedent that led to this decision gets overturned. And also too, the Court of Appeals in this case noted that some negligence claims could still survive if a plaintiff is able to show that their injuries were also sustained by the defendant's conduct that was unrelated to the dangerous condition of the land. So it's not always the case that they're not going to be able to bring a negligence claim. They may still be able to bring those, just that in this case, the plaintiff didn't have enough facts to do so. And an additional caveat here, the precedent of condominium associations don't owe a duty to their co-owners under premises liability claims for injuries stemming from the common elements. That applies to condos and co-owners. So if you're a subdivision association, that case may not apply to you, especially if your homeowners do not jointly own or have an interest in those common elements. And even for condos, that is not necessarily going to apply to people who are not co-owners. So people who are guests in slip and fall, that precedent is not necessarily going to apply to them either. All right, so with all that fun stuff said, a week after Jones, another case came out of the Court of Appeals. Again, another unpublished decision. So persuasive authority only, not binding on the trial courts. Similarly, the issue on appeal was whether the condo association and the property management company were liable for a co-owner's injuries that were sustained from a fall on an uneven, deteriorated common element parking lot that had exposed metal protruding from the pavement. Here, the co-owner alleged that the condition of the parking lot was caused by the removal of a garage in 2013. There was a dispute as to whether or not the co-owner had notified the association and management company regarding the conditions prior to her fall. And in this case, the co-owner filed not only premises liability negligence claims, but she also filed claims for violations of local ordinances and a breach of contract claim against the association and management company. So here it was a mixed result. The Court of Appeals affirmed parts of the trial court's decision and reversed other parts of it. So the trial court did dismiss the premises liability claim based off of the precedent that we had just discussed. Because remember here we have a condo association and co-owner, so they found no duty. But where the Court of Appeals reversed the trial court was regarding the violation of local ordinances and negligence claims against the management company. So first, the co-owner had attempted to hold the association responsible, saying the conditions of the parking lot violated local laws. And because of that, the Michigan Condominium Act includes a provision that says condominium projects have to comply with local laws. So the co-owner attempted to hold the association liable for those apparent violations of local ordinances. The Court of Appeal said, yes, we understand the Michigan Condominium Act requires projects to comply with local laws, but that does not provide you with a co-owner with a cause of action against the association if there is a violation of local law. Court of Appeal said instead, you basically need to seek enforcement through local law enforcement your typical ordinance violations, things of that sort. So that claim was dismissed. For the co-owner's negligence claim against the management company, her claim was largely based off of the management agreement between the association and management company, wherein the two of them had decided, hey, management company, we would like for you to take care, maintain, repair, and replace our common elements. And the Court of Appeals said, you co-owner don't get to bring a negligence claim because you are not a party to that agreement. It was between the association and the management company. And there was nothing within the contract that said that the co-owners were intended to benefit from that agreement between the association and the management company. And also too, she didn't identify any duty separate from that management contract that the management company owed her. So that claim against her was also dismissed. So the takeaway in this case, very similar to the previous case, Jones, but this also provides some additional legal guidance when a co-owner suffers personal injuries from the common elements, but they attempt to try to get around the issue with the premises liability claims by trying to bring in other potential claims against the association. So here, violation of local ordinances and negligence stemming from a management agreement or agreement with a management company. So that wraps up premises liability. Again, lots of potential shifts in this next year. So stay tuned on those. For my favorite topic, short-term rentals, we have two important cases that came out this year. The first of which is a published opinion, which means that it is binding on Michigan trial courts. And it came out in January 12th, 2023. So a little bit over a year ago. So the issue on appeal here was whether residential use and single-family residence restrictions were sufficient to prohibit short-term rentals. So the restrictions did not specifically or expressly state no short-term rentals. This community was rather large. It consisted of a mixture of residential lots, residential condos, commercial property, recreational areas. And as I said, the only language related to rentals was just to say, can only use your property for residential purposes, and we're only going to allow single-family residences. So based on prior case law from the Michigan Court of Appeals regarding short-term rentals, the association adopted a resolution that said no rentals less than 6 months are going to be allowed in this community based off of these two restrictions that we have. So naturally, two members who wanted to engage in short-term rentals filed litigation saying, listen, these restrictions don't expressly prohibit short-term rentals. They don't expressly prohibit any commercial activities. So we should be allowed to continue with our short-term rentals. The trial court, the Court of Appeals ended up actually reversing the trial court, and they held that, yes, short-term rentals are a commercial use of property, and therefore they violated the residential purpose and single-family residence restrictions in this case. So that is consistent with the prior case law that's come out in Michigan. What was important for this case was the last published opinion that we had out of the Michigan Court of Appeals relating to short-term rentals was in 2017. So this was the first case in 6 years that we actually got binding authority regarding short-term rentals, and again, reaffirming short-term rentals, even if they're residential in nature, are going to be considered a commercial use of property and generally are going to violate residential use restrictions. In this case as well, there was a little twist of, as I mentioned before, it was a very large community. There were some areas of the community where commercial use was permitted, but in this case, the plaintiff's properties were not located in those areas where commercial activities were permitted. So the Court of Appeals said, listen, the restrictions contemplate where commercial activities can occur. That's not where your properties are located, so no short-term rentals for you. So this case continues to be a great positive outcome for community associations. This can apply to condos and subdivision associations alike, especially those who do not have provisions that expressly prohibit short-term rentals. Again, though, similar to the fines cases, there are caveats here of these cases are decided on a case-by-case basis. And they're going to largely turn on whether or not there's a permanent presence at the property and whether individuals at the property have the right to occupy it and leave their belongings there and return to the property whenever they desire. So we have a lot of case law to support short-term rentals are going to violate residential restrictions, but it still is going to require a case-by-case analysis as to whether a short-term rental within your particular community is going to violate any restrictions that your community may have. And then over the summer, we had another short-term rental case out of the Michigan Court of Appeals. This one is unpublished, so it's not binding on the trial courts. However, it has been appealed to the Michigan Supreme Court, and we're waiting to see if the Michigan Supreme Court is going to take it up and if a different result is going to occur. But similar to Aldrich, we have here whether a single-family residence purpose restriction was sufficient enough to prohibit short-term rentals in this community. This community, as opposed to Aldrich, was much smaller, only had 9 homes. 7 of those homes were owned and occupied for at least 6 months out of the year. And the other 2 were owned by individuals, one who resided in England and one who resided in the state of Washington. And as you can imagine, they didn't make it back to their properties frequently or not at all to use them themselves. There was evidence that this community historically had permitted owners to basically engage in short-term rentals with friends and family. And the 2 out-of-state owners said, hey, we bought these properties with the idea that we were going to short-term rent them so that we could actually finance our purchase of them. So they tried to make an argument of basically we relied on our ability to short-term rent in order to buy these properties. So eventually the association decided to do away with these short-term rentals, and they filed litigation against these 2 out-of-state owners. So this time the trial court got the decision right, and the Court of Appeals affirmed, saying, yes, your single-family residence restriction here was sufficient to prohibit these short-term rentals. And I pulled 2 excerpts out of the opinion because I think they summarize the decision pretty well. The first is that the Court of Appeals focused on what a residential use restriction is designed to accomplish. And they said here that a residential purpose is the one place where a person lives as their permanent home. And when applying that standard, a summer home cannot constitute a permanent residence when a person's domicile is in another location. A residence reflects a permanence and continuity of presence. So here, the Court of Appeals really focused on the fact that these were out-of-state owners who basically made no use of the properties themselves. And again, focused on not only is it serving as a vacation rental for your transient tenants, but it's also serving just as a summer home for you, the owners yourselves. You also don't have a permanent presence at this property. As it relates to the out-of-state owners, they try to say, hey, this community's promoted short-term rentals before. Other people have been allowed to short-term rent to their family and friends. So the association can't bar us from short-term renting now. And the Court of Appeals said, occasional rentals do not alter the character of a subdivision. They don't defeat the original purpose of the restrictions, and they don't result in a waiver of those restrictions. So the association's prior history of allowing occasional short-term rentals was not enough to defeat their attempt to prohibit these short-term rentals by these out-of-state owners. And the Court of Appeals also rejected that argument because they had what's called an anti-waiver provision within the restrictions, which basically is language that says, hey, if we, the association, fail to enforce this restriction, that doesn't mean we waive the restriction and we can enforce that restriction in the future. So Again, this is another positive outcome for community associations, especially those dealing with short-term rentals and who want to prohibit them, even if you don't have express language in your restrictions. However, again, there's an emphasis on these cases are decided on a case-by-case basis. And this particular case, we have here out-of-state owners who are making no use of the property really themselves, along with their transient tenant who don't have a permanent presence at the property. And I think this case is another good reminder of if there's just occasional rentals going on, that may not be enough to be barred by the restrictions. So I think what the Court of Appeals is looking at is an owner who is not permanently residing at the property and transient tenants who also are not permanently residing at the property. But occasional rentals, these one-offs to family and friends may not be enough to say that's a short-term rental that needs to be prohibited. All right, so next up, sex offender restrictions. So both of these cases, we have two that we're going to discuss today, come from out of state. So these are not Michigan cases, but they provide two very different decisions on the enforceability of sex offender restrictions that may end up impacting Michigan law if and when this case comes up to a Michigan court. So the first case is actually from 2022, so it's sliding into the 2023 case law update, but it's a published opinion out of the Pennsylvania Court of Appeals. And in this case, the issue on appeal was whether a restriction that prohibited Tier 3 sex offenders from residing within the community was enforceable. So here, the restriction was adopted by 71% of all the owners, and it was recorded in 2016. The homeowner, the defendant at the time, had actually resided within that community for decades and prior to the adoption of this restriction. However, he was convicted of crimes and required to register as a Tier 3 sex offender around the same time that this restriction was adopted. Eventually, he was released on supervised parole back to his home within the community in 2018. So the restrictions in effect, but the parole board had determined, we're going to release you, and we're going to release you back to this particular home within this community. So the association said, hey, you're a Tier 3 sex offender, you can't reside here, so you need to vacate the property, you need to leave. So the Pennsylvania Court of Appeals, if we can get this to move, affirmed the trial court decision, which said that this restriction was not enforceable. And so this homeowner was not going to be required to leave his property. And the trial court and the Court of Appeals got to this decision by determining that Pennsylvania's laws regarding the rehabilitation, release, and reintegration of sex offenders basically established a public policy of we, the parole board, are going to determine when, where, and how to release a sex offender. When we do this, we are taking into consideration public safety, rehabilitation, things of that sort. And so you, a private community, cannot substitute your discretion for our discretion. And so basically the Court of Appeals said all of these laws regarding the reintegration, rehabilitation of sex offenders has established a public policy of where they can go, where they can relocate once they're released on parole. And because of that public policy, any restriction that attempts to override that is going to be unenforceable. And here I also included language from the opinion itself, which I thought was interesting, kind of summarizes the decision in this case. So it says, while a private community has a legitimate interest in providing a safe living environment for its residents, the Commonwealth's legislative measures governing the release of convicted sex offenders were specifically designed for the protection of the public. And the Court of Appeals also noted that all of the dangers complained of by the Lake Naomi residents will then be thrust upon other residents of our society, perhaps just down the road for them, who don't live in a private community. So at least in the state of Pennsylvania, these restrictions that prohibit sex offenders, or at least tier 3 sex offenders, from living within a particular community are not going to be enforceable. However, the state of Illinois, or at least a trial court in Illinois, recently adopted a different position. So here, the issue is whether the restriction, whether a restriction that prohibited just registered sex offenders, typically you see tier 3 sex offenders. This one just applied to registered sex offenders across the board. Whether that restriction that prohibited them from residing within the community was enforceable. So there were some slightly different facts in this case. The restriction here was adopted and recorded in 2009. And the homeowner bought his home and became a member in 2012. So before, we had a homeowner who resided in the community before the restriction was adopted. Here, we have a homeowner coming into the community after the restriction has already been adopted. After he moved into the community, he became a registered sex offender in 2021. So the association filed litigation to enforce that restriction, require the homeowner to vacate the property. In this case, the Illinois trial court determined that the restriction was enforceable. They actually looked and considered the Pennsylvania case that we just talked about. But here, the trial court said, we don't find anything within the Illinois laws that indicate that there's a public policy that these sex offender statutes regarding their rehabilitation, parole, relocation when they're on parole, that these are supposed to serve as the exclusive method of protecting the public from convicted sex offenders, or that they will preclude a private community from adopting restrictions to limit their occupancy within their particular community. So Pennsylvania said, our sex offender laws have created public policy. Private communities can't override that public policy. Illinois said, yes, we have sex offender laws, but we don't think they establish public policy, and community associations, private communities can still adopt their own restrictions to further prohibit sex offenders from living within their communities. And here, as I mentioned, the Illinois trial court also focused on the fact that this homeowner bought into the community with knowledge of the restriction. So he was well aware that if he ever became a registered sex offender, that he would be asked to vacate the property. And the Illinois trial court also noted that sex offenders are not a protected class. So the restriction was going to be enforceable. So this opinion just came out of this Illinois trial court. We're going to need to see if it gets appealed up to the Illinois Court of Appeals, and if the Illinois Court of Appeals has something different to say. However, it does still serve as good persuasive authority for associations in Michigan, and if a similar argument is raised here in Michigan. So Michigan has not yet answered this question of whether sex offender restrictions are going to be enforceable, if they're going to violate Michigan public policy or not. But this case certainly serves as persuasive authority that there shouldn't be a public policy on this, and that they should still be enforceable. Because though this is still very much a gray area in Michigan, if your community does have a sex offender restriction and you do have a sex offender within your community, you should reach out to an attorney to get advice on the potential risks if you decide to move forward with enforcing it, because we just don't have a lot of case law on it right now. So there is some risk there. All right. So wrapping up with our two final cases, emotional support animals. I think associations, one of their favorite topics and issues to deal with. So this case has a lot of facts to it, which is why this slide is very wordy, but I think it helps shed some light on the issues involved here. and probably present some similar facts and circumstances to what associations have encountered before. So this is Whitaker versus Southgate. It is a published opinion out of the federal Eastern District of Michigan. So federal decisions out of the district courts are not necessarily going to be binding on the state courts, but they could be persuasive authorities. So here we have an individual who requested a reasonable accommodation of a city's ordinance to keep 6 chickens as emotional support animals. So not 1 or 2, but 6 chickens. So the facts here involve basically Whitaker moves to Southgate in 2021. He brings with him his 6 chickens. The city's ordinance prohibits the keeping of chickens. So he gets issued a citation. He initially defends against the citation, saying he's allowed to keep the chickens under Michigan's Right to Farm Act. He then learns that the Right to Farm Act is not going to apply to his situation, but he continues to keep the chickens, gets a second citation. So at that time, he goes and he gets counseling from a mental health provider for depression, anxiety that he's apparently suffered from for many years. And he says that those conditions have now been exacerbated by the fact that he might lose his chickens. He gets a letter from that mental health provider saying, yes, we're confirming that you have these diagnoses. You might need a reasonable accommodation to keep these chickens as your emotional support animals. So he requests a reasonable accommodation from Southgate to keep them. Southgate denies that request. They continue prosecution on that second violation. He then goes to a different mental health provider who reaffirms his mental health diagnosis and again concludes that all 6 of his chickens are his emotional support animals. So he makes a third request to Southgate. Southgate denies that request as well. So he eventually files his own litigation in federal court saying, Southgate, you violated the Fair Housing Act and the Michigan Persons with Disabilities Civil Rights Act because you failed to grant my reasonable accommodation request. So with all that lengthy background, the federal district court denied Southgate's motions to dismiss the case. So Southgate tried to tell the court, just get rid of this case. This was not a reasonable accommodation. This was not a reasonable request. There's nothing to see here. District court said no, and I think that there's questions of fact and it needs to go to trial. And it primarily focused on that, in the district court's opinion, that there were questions of fact regarding the reasonableness and necessity of the accommodation request. So first, as to the reasonableness of the request, the district court noted that there was competing evidence on both sides. So from Whitaker's side, he basically had argued that the chickens provide me with support. My mental health condition would be negatively impacted if I was forced to remove my chickens. I comply with guidance on poultry management. Basically, I keep them in a safe manner. And there's no hardship or burden that Southgate would face if they allow me to keep my chickens. Southgate, on the other side said, this request is not reasonable because chickens can carry pathogens that pose a public health risk. And that's going to impose too much of a burden and a hardship on the city trying to mitigate that risk. So the district court said, there's competing claims here on both sides. This needs to be decided by a jury. As to the necessity of the requests, again, the district court determined there was competing claims on both sides. Whitaker here apparently had evidence or testimony from his mental health provider that said that the chickens provided him with a purpose, and also too that the chickens functioned as a unit. And so the removal of any one of them could negatively impact the flock and therefore Whitaker's disability. So going to the question of why do you need 6? Why not just 1 or 2? And so there was testimony and evidence there as to why he needed the 6. On the other hand, Southgate said there's no evidence here that Whitaker needs all 6 chickens. And also, why is it that only chickens can provide him with the support that he needs? And so the district court said it's too early for this decision to be made, and it needs to be decided by a jury. I looked this case up last night. It actually settled shortly after this decision. So we, I guess, will not know whether or not 6 chickens in this case were a reasonable or necessary accommodation. But I think what this case, even though it involves a homeowner and a city, similar rules and regulations and elements apply between homeowners and associations. And so I think what this case really teaches is that requests for reasonable accommodations for emotional support animals always have to be taken seriously. It needs to be reviewed and considered on a case-by-case basis. And while I think some of us can look at it and be like, 6 chickens as emotional support animals, are you kidding me? I think what this case teaches you is that even requests for multiple emotional support animals or non-traditional emotional support animals cannot be automatically dismissed, discounted, or denied. You still need to go through. It is possible for somebody to potentially make a reasonable accommodation request for more than one emotional support animal and for a non-traditional animal. So make sure that you're reviewing those requests and taking them seriously. All right, so the last case for the time being is, or for this evening, so interest and usury. So this case does not deal with condominiums and homeowners associations. However, it deals with loan agreements and interest and usury rates. But as we'll discuss, it could provide some guidance and have some potential impacts on condominiums and homeowners associations, particularly when it comes to collecting unpaid assessments. So this is a published opinion out of the Michigan Supreme Court. It's Soaring Pine Capital Real Estate and Debt Fund 2, LLC versus Park Street Group Realty Services, LLC. And so here the case dealt with a loan agreement that included what the court determined to be an illegal interest rate. So the agreement basically said, we're going to impose a 20% interest rate, which is permitted as a loan agreement in this particular case. But we're also going to have fees and charges as well for other things. So we're going to label this as 20% interest. And these other things we've labeled as fees and charges. But when you considered that interest rate and the fees and charges together, in effect, it resulted in a 25% interest rate, which was illegal. And so the Michigan Supreme Court had to decide not only whether was the interest rate illegal, but also too, if a provision within the agreement that said nothing in this agreement will be construed to impose an illegal interest rate could be enforced. And then also too, interestingly, whether that lender committed a crime by filing litigation trying to collect on what the Michigan Supreme Court determined to be an illegal interest rate. So here the court said that that provision which said this is not going to be considered an illegal interest rate could not be enforced. But they also said as well, listen, we're not going to say that this lender committed a crime here by pursuing collection of these amounts via litigation. Basically, the Michigan Supreme Court said, you know, we prefer people to file litigation and seek to enforce their rights that way than to undertake other abusive self-help remedies. But importantly here for associations to consider is that when determining whether or not an interest rate and other fees and charges might impose an illegal interest rate, the court said you have to look beyond the labels and words. So just because the agreement said this is interest, these are fees, these are charges, we're not just going to look at those. We're going to look at the underlying purpose of these late fees, charges, etc., to determine whether or not this is really just a form of interest and therefore whether it's imposing an illegal interest rate. And so where this primarily comes into play is for associations is when you think about your collections of assessments, and the application of, when an assessment goes unpaid and you're trying to collect, when you're imposing both an interest rate and late fees and charges on those unpaid assessments. So big takeaway from this case, again, it didn't target condos and homeowners associations particularly, but it does provide associations with something to consider when they're imposing interest and late charges on unpaid dues and assessments. So particularly when it comes to late charges. So a lot of associations will have language that says we can charge a late fee or a late charge of such amount of dollars. And so this case provides some guidance that if an association is going to charge a going to assess a late fee or a late charge, you're going to have to be able to tie it back to the actual administrative costs that the association incurs related to the unpaid assessment, the delay in getting the money back. The late charges, late fees should not be designed as a penalty, basically as a punishment or a stick for co-owners or homeowners who fail to pay their assessments on time. And they should be reasonably related and tied back to the actual cost that the association incurs when they don't get a payment or when they don't get a payment on time. That will support an argument that when we say this is a late fee or charge, it's literally a late fee or charge. It is an actual expense we're incurring, and it's not interest. Especially if the association, when collecting on unpaid dues and assessments, is going to apply both interest and late fees and charges. So again, it doesn't hit on specifically condos and HOAs. We haven't yet seen a case in the Michigan appellate courts dealing with does the imposition of both interest at the legal rate plus late fees and charges, does that, is that a collection of an illegal interest rate? But I do think associations can take some guidance from this case in making sure that late fees and charges are reasonable and reasonably tied to the actual expenses that are incurred when you either don't get paid or get paid late. And again, making sure that they're not just serving as punishments or carrots for co-owners who fail to pay or fail to pay on time. All right. So with that said, we have come to the end of the presentation. So a lot of info from today's case law update, a lot of positive results for community associations, but also a lot of potential changes in the future, particularly when it comes to premise liability claims and potentially sex offender restrictions if a case like that comes up in the Court of Appeals in the near future. So with that said, I'm happy to open up to questions about the cases in general. If you have a question specific to an issue to your condominium or your subdivision, it's very likely that we're going to ask to have that conversation offline to provide you with a specific opinion on your specific issue. But any questions on what happened in 2023, what might be happening in 2024?
I have a question, Kayleigh. Do we have a duty to review the sex offender reports? And also then how to put the restriction in the bylaws, if it has to be a bylaw amendment, or can the board do a restriction like that? So 2 questions there, I guess.
Yeah, so the sex offender restriction, if your association's interested in including it within your documents, that does need to be either an amendment to the bylaws or amendment to the declaration. So will require approval by your members or your co-owners, whoever that may be.
Okay.
In terms of a duty to look into the reports, I mean, that information is available. I don't have an exact answer to that. I will say that information is available online. And so there's a sex offender registry list online. So if you know the person's name, you could look it up and determine whether or not they're on the sex offender registry list. I do think sometimes it's difficult, though. I did this recently. I don't believe that they tell you online if they're tier 1, tier 2, tier 3. Many times it actually requires you to figure out what they were convicted of, and then to go into the statutes and figure out, does this classify as tier 1, tier 2, tier 3? So there is some information available online, but you might have to do some additional digging to figure out whether and how they're classified. But also too, sometimes local police agencies, if you become aware of a sex offender in your community, sometimes you can reach out to the local police agency and they can give you more information about what tier they're in, if they're complying with the reporting requirements and things of that sort.
Thank you.
So I do see a general question here. If you have short-term rentals, and you prevent renters from having pets, can emotional support animals be included in that restriction? I.e. no pets. So the general answer to this question is going to be no. Emotional support animals are not generally considered to be pets. So if somebody has a legitimate need for an emotional support animal, even if it's a tenant or a renter, and they make a request and provide you with the documentation that is needed to certify that, yes, I have a disability, I need this accommodation, you're likely going to have to accommodate that request, even if there's a general prohibition against animals within the condominium, whether it applies to members or renters.
I have a question.
Yes.
In your last area that you discussed on interest, and you were talking about late fees should not be penalizing, but should more reflect the cost to the association for collection. Could you be more specific as to what you would consider in arriving at what the cost would be to you for collecting? I'm a little unclear of what exactly, how you would figure that out.
Yeah, so of course, it's not always going to be something that is going to depend association to association and how they operate. But what we generally recommend is that around a $25 late fee or late charge is something that, I mean, of course, we don't have case law to support that, but it does seem to be more in line with what would be considered to be reasonable. And thinking about the potential notice that the association is going to have to send to the association, to the co-owner or member, and just the administrative cost of reviewing the account, determining that it's delinquent, contacting them, attempting to get paid, things of that sort. You know, the higher the late fee and late charge gets, the more likely it is that it's going to be considered to be unreasonable, and potentially, you know, if challenged, potentially a co-owner, a member might be able to argue, this actually is not a late fee or a charge. This is actually basically interest. And so it needs to be lumped into that category.
So it really wouldn't be associated necessarily like a percentage of what the dues amount actually is. Like if you only charged $50 for like an annual dues or whatever your assessment is, as opposed to $300, $25 you're saying would be a good place to start.
So if you have a smaller annual dues, though, it's also, you will also need to take into consideration what the dues are. So, you know, if you have like a very small annual due, if your dues are only $50 a year, a late fee or late charge of $25 for that payment's probably going to be, it could potentially be considered unreasonable because it's about 50% of the principal.
Right.
So you will need to take into consideration too, what's the overall principle that we're dealing with here? And also, what are the actual costs that the association's incurring because somebody's paying late or not on time?
Thank you.
Let me see. Any other questions?
Kayleigh, I have a question in the chat.
Let's see. Managing emotional support animals at the community swimming pool.
Yes.
Yeah, so I don't have an opinion on that. So that would be something I would have to get back to you on, in dealing with them in like common recreational facilities, basically. Yeah, that would be
Thank you.
something I need to take a look at.
Okay.
Kayleigh, I have a question there. I put it in the chat also. I don't know if you're familiar with the Senate bill on short-term rentals. It was a House bill that then got kicked to the Senate, and it's been sitting in the Senate for about 2 years. And unfortunately, I'm not finding it at the moment.
Yeah.
Are you familiar with either of those?
So, I'm familiar with the one that you're talking about. That actually ended up dying because the legislative session ended and it didn't go anywhere. However, I am aware that a new short-term rental bill has been introduced. I haven't looked at it in detail. So I can't provide you with much information beyond that, but I am aware a new one has been introduced. I've actually been kind of surprised it's taken them this long, because I think the last legislative session ended 2022. So it
Yeah,
seems
you're
like,
right.
yeah, this one has taken a while, but it's back. I'm pretty sure it's going to be similar to what was proposed a few years ago. I just haven't taken a look at it.
Yeah, the one
Yeah.
from the House Bill 4722, I just ran across. It was from March of 22.
Mm-hmm.
And my understanding is that got kicked to the Senate, and I had the Senate bill number. I'm not in it at the moment, but they sat on it for about 2 years. So now there's a new one introduced, you're saying?
Yeah. Yeah, that one died at the end of the legislative, I believe that legislative session ended at the end of 2022.
Okay.
So we're in a new legislative session now. And so, yeah, a new bill was just recently introduced.
Okay, so that old Senate bill did die with the
Yeah.
turnover into the new. Okay.
Yep. So yeah, if you look it up, if you go to like the Michigan legislature page to search bills, you could probably type in short-term rentals and that new one will come up. And you
Okay.
can track it and see what's going on with it.
Okay. Thank you.
Yep.
I had another question in the chat regarding the sex offenders. Putting that in your documents or if adding that as an amendment, aren't you opening yourself up to liability to have to check every homeowner every year? I mean, I don't know what kind of liability would happen if you missed that. You know, say, I mean, somebody's going to have to check every year because in your example, if you did not meet a sex offender and put 10 years later, he was one, and then somebody found out. So how would you navigate that process without getting yourself in trouble if you miss it?
Yeah, so unfortunately, this is another one that I would need to look and see like what the potential liabilities are. But at least the instances that I'm aware of, the association does find out. I mean, I think, you know, in the instance in the Pennsylvania court, I mean, this guy was away for a few years. So I think that there, you know, was some indication to the association that something had happened. And same thing too with the other homeowners, people who had already bought in, you know, these people are going away and spending some time. So the association, I think at least had some knowledge that something was going on, was able to investigate it a little bit further. But I mean, you're right, you know, how often does the association have to, you know, when somebody buys in, do you need to look them up? If you have tenants and renters coming in, do you need to look them up? Do you need to go through your roster of people every single year? That would be something I need to look into a little bit more to see what the potential duties are there and what potential liabilities there might be.
Yeah, we decided to keep it out because we are in a resort community where 70% of our owners are part-time owners, and we do have short-term rentals. And we just felt the liability of keeping track of them, or having our other co-owners believe we're keeping track of them, was too much liability to occur in our situation.
Sure. And then the last question I see is Kathleen on short-term rentals. So this says, is an association that's known for short-term rentals waiting for a lawsuit by an opposing owner and opening yourselves up to defending positions. So I think that is going to largely depend on the language within the documents. So if the documents say, many condominium, not all, but many condominium associations have language saying, we, allow rentals, they have to be for a minimum term of, however many days, 30 days, 60 days, whatever. But if the condominium documents say, we allow rentals as short as 3 days or 7 days, I think it'd be a difficult case for a co-owner to say, you shouldn't be allowing short-term rentals when the documents expressly say we allow short-term rentals, essentially. If a co-owner is dissatisfied with the short-term rentals within their community, and the language specifically says you can have short-term rentals, their option at that point would be to propose an amendment to the bylaws and see if they can get enough co-owners and for condos mortgagees to approve that amendment to prohibit them. So a lot of it is going to depend on the language within the documents, and certainly the documents expressly say short-term rentals are permitted. Then the association allowing short-term rentals, which the documents say that you can do, that's going to be a difficult case for that co-owner or a member to make.
I think my question too, just meant, because of the residential meaning, now that it's been out in the courts, we have opposing sides. I think a lot of people will.
Yeah, I think though, those other cases though, didn't say anything about rentals at all. It just said residential uses, maybe a single family residence restriction. There was no language in there regarding renting and leasing.
Okay.
And so that's where the argument came from is, well, based off of these restrictions, short-term rentals aren't allowed. So if there is language that says you can engage in rentals of this length of time, potentially qualifying, as a short-term rental, that's going to be a different case.
Thank you so much.
Yep, no problem. All right, so thank you for joining for the 2023 case law update. Hope I have put a lot of potential things on your horizon for 2024. And with that said, we will wrap up this session and everybody have a great night. Bye.
Bye.